Is a non-compete clause within an employment contract enforceable? Seemingly simple question, but actually it's not a simple answer. The question from the perspective of the employment tribunal, or indeed the courts, is whether or not what the employer is trying to protect by that non-compete clause actually represents legitimate business interest, or whether they're simply trying to stifle competition. Now, employers will spend a lot of time and resources building up relationships with clients, building up relationships with intermediaries, and they have a legitimate right to protect those relationships that they have built up. But if what they are doing is in fact trying to simply stifle competition after, for example, an employee leaves, then that isn't a legitimate right that they can protect. It's against the public interest if that were to be allowed to be the case. And so that essentially makes the distinction that the courts will apply when faced with that question. In other words, if it's a legitimate business interest that's being protected, the courts will usually uphold that. But if it's simply trying to stifle competition, they won't.